Will the courts then across the country follow the bail not jail principle? Is trial delay a good ground for bail in a PMLA case? Does the Sisodia case now bail spell hope for Kejriwal and others who have been tangled in jail for a long time? Joining me now at the very top is Abhishek Manu Singhvi. He is, of course, senior counsel, was appearing in the case and senior Congress leader as well. Appreciate your joining us, Dr. Singhvi. Why do you think this judgment is significant? When Justice Gawai says bail not jail, he's only reiterating what we all know. So why is it that it becomes so significant at the moment?
Palkiwala once said, Rajdeep, that the restatement of the obvious is sometimes vital because a lot of people other than this bench seem to have forgotten it. Now, let me answer your questions which you're showing on your screen one by one very quickly in the limited time available. First and foremost, I think this judgment establishes the old basic principle of bail jurisdiction that it is a robust, commonsensical, not too much of high-flying jurisprudence, not wastage of time. This bench got the matter, it heard the matter in a very short while, it reserved orders and delivered judgment promptly. That is how bails are to be rejected or accepted. That is robust, commonsensical judging. It is not some high jurisprudential flights, which sometimes different benches seem to take.
No, but it's taken 17 months. Sorry to interrupt. It's taken 17 months for the court to get to this point.
No, I am talking about this bench. This matter reached this bench not even 17 days ago or 17, some very short while ago. Now, why is it taken? I'm coming to that point. That's a very important point you're raising. But let me tell you the legal principle which this judgment establishes in sequence to several earlier ones is that 45, which is supposed to be the bugbear, a synonym for not releasing you, special conditions, will be trumped, will be overridden by the larger, higher constitutional guarantees of anti-delay, Articles 20, 21 and 22. Do you see you need to have, this is only a statutory provision. This cannot excuse or keep you behind for inordinate delay. You must be able to show, of course, in a particular case delay. Here, there is no possible end to the trial in sight. Two earlier, or in fact, three earlier Supreme Court orders have underlined delay. So that's the heart of the principle. But see this judgment as a continuum. I have had the privilege of appearing in three matters where Kejriwal has got bail in PMLA. The principles established are grounds of arrest, reasons to believe. And today, Justice Gawai's order is very significant because in the context of 45, it uses and applies the principle bail, not jail. Now, your question is the core question. Why do we keep coming here? Really speaking, there is a subtext of a lament in the judgment. It is high time the judgment says that trial courts and high courts simply decide it on these broad principles. As I always say, they have nothing to lose except their inhibitions, their hesitations, which are mystical. Today, most of these matters need not even reach the Supreme Court. If they reach the Supreme Court, your 17 months is answered. There is a process, there is a ladder. In this case itself, there was an unfortunate preliminary objection by the government which said I should be made to go all the way again back to the bottom because of a certain interpretation of an earlier order of the Supreme Court. In a paragraph, the honorable judges have debunked it rightly, saying that this would be a game of snakes and ladders. So your 17 months are very often spent in this futility of exercises, not keeping in mind the larger paramount paradigm of liberty of the individual.
Yes, but
you welcome this judgment.
Yes, but Dr. Singhvi, the fact is, we are here dealing with the former Deputy Chief Minister of Delhi. What about, there are thousands of under trials in this country who again go through this process of snakes and ladders. I go to a lower court, I'm told lower court won't give me bail, I have to wait till the Supreme Court. So, at least Manish Sisodia gets, because of being a Deputy Chief Minister, perhaps gets a benefit that otherwise many others would not, particularly under PMLA.
I'll tell you, in PMLA especially, if you are a supposed VIP, if you are a political figure, the courts are more hesitant. It's the other way around. If you have the anonymity of not being in public life, you are more likely to get bail. That is really the problem. The courts become conscious. The courts become hesitant. There are any number of people who have got bail and should get bail. In the public life sphere, fewer and fewer get it, which is why these court matters land up as so-called high-profile cases in the Supreme Court.
No, so will today's order change anything? Do you believe today's order will will make it easier for high-profile detainees, the likes of Arvind Kejriwal and others, to actually get bail? Will that actually happen?
Well, in operational reality, jolly well should. The Supreme Court's orders are supposed to be implemented in letter and spirit. You don't need the Article 141 and 142 of the Constitution to tell us. They have to be. Now, this is the third, fourth time. Remember, there are 3 Kejriwal orders. There is a Sanjay Singh order. There is a Praveer Purokasta order. There are 2 recent judgments on delay in more serious UAPA offences. The point is that this message is driven home. I believe different benches of the Supreme Court have to be more consistent in repeating this message. If the consistency of different benches in the Supreme Court is there, then there is no question that every trial court and every high court in the country must follow this.
But I will ask you this in conclusion, because the trial courts and the high courts across the country are not following it. They seem, as the court itself says, to be too cautious, too unwilling to take a risk in granting bail, which is crazy at the moment.
That is very unfortunate. And the court repeatedly, in this case especially, has rightly underlined it. Absolutely correctly. Now, you know, the Supreme Court, our court system has a limitation that they deal with the case before them. The Supreme Court or the Chief Justice of the Supreme Court, Justice Gawai, can't get up and go to each High Court and say, look, decide this way. They deal with the case before them. Therefore, this message has to be picked up. The problem is, if you don't pick it up, then more time is wasted. I come to the Supreme Court where I get bail, which is why 5 months becomes 10 months, 10 becomes 17 months. Okay. And that is something to be deprecated. As I always say, you have nothing to lose except your inhibition. There is absolutely no reason for fear. The law is clear.
In your view, therefore, is Arvind Kejriwal likely to get bail within a month now?
Now, I have been very free in talking about the Sisodia case because it's over. I'm not going to be that free in talking about a sub judice case, but I can tell you one very striking, unprecedented, unusual thing about the Kejriwal case. It deserves underlining. Kejriwal's case is the only case, perhaps, and certainly one of the few I have done, where I have been successful in getting 3 release/bail orders. One, of course, has been stayed, but 3, 2 by Supreme Court, 1 by trial court. And these are all 3 PMLA release orders. I have yet to come across a case, Rajdeep, where a PMLA release order is followed by a CBI arrest. And CBI, which has got no Section 45, bail is denied. Whereas in the one which has Section 45, you released him 3 times.
Very, very interesting point that you're making there, Dr. Singhvi, and it therefore points out to the fact that many of us believe something in our judicial system will have to give, and will have to ensure greater consistency so that the right to life and liberty under Article 21 is underlined in each and every case in this country. That, to my mind, is perhaps one of the messages that the court, Apex Court, sent today. I appreciate, Dr. Singhvi, you taking the time to join us here today to give us your sense of why you believe this judgment is important once again. I want to play out just now what Manish Sisodia, he came out of jail, Tihar jail, about a couple of hours ago. Listening to what he had to say, he sounded like someone who's now determined to take the fight ahead. Listening to him.
उन्होंने संविधान की ताकत का इस्तेमाल करते हुए तानाशाही के मुंह पर एक तमाचा मारा है। आज मेरा रोम रोम, जब से यह ऑर्डर आया है सुबह से, मेरा रोम रोम बाबा साहब के प्रति ऋणी हो रहा है। एक एक पल मैं समझ नहीं पा रहा हूं कि आज इतने दिनों बाद, इतने वर्षों बाद बाबा साहब के प्रति कर्ज को हम कैसे उतारेंगे। उस वक्त उन्होंने तय कर लिया था कि आने वाले समय में अगर कोई तानाशाही सरकार आके निर्दोष लोगों को जेल में डालेगी तो संविधान इसको बचाएगा। आज मैं बाहर आया हूं तो आपके प्यार की बदौलत, आपके प्यार के साथ साथ भगवान के आशीर्वाद की बदौलत, सच्चाई की ताकत की बदौलत, और सबसे बड़ी चीज जो बाबा साहब ने जो सपना देखा था कि कोई तानाशाही सरकार आएगी तो तानाशाही भरे कानून बना बना के जब नेताओं को विपक्ष के लोगों को जेल में डालेगी तो इस देश का वो संविधान जो बाबा साहब ने बनाया था मैं आपको अपील दिलाता हूँ, इसी संविधान की ताकत से हमारे प्यारे नेता अरविंद केजरीवाल जी भी बाहर आएंगे। अरविंद केजरीवाल जी चले जेल के ताले टूटेंगे, जेल के ताले टूटेंगे। ये संविधान की ताकत है कि हमारे प्रिय नेता, इस देश के लोकप्रिय नेता और इस देश के एक बच्चे के लिए शिक्षा पर काम करने वाले नेता अरविंद केजरीवाल जी जल्दी।
Okay, remember, as I said, this judgment has political and legal implications. Bail, not jail. Or is it jail, not bail? You decide. The courts certainly have sent out a strong message.